If I may request my lordship to unmute the court proceedings. Deeply obliged.
Which class students? Tomorrow it can be listed.
All the transportation materials they put now. There you see border line. Both will have
Tomorrow for what? Which case? Education. Huh? It's not being listed. Find out. I think there must be something there. All right. All right. Friday action. Payment. ನೀವು ನಿಧಾನಾಗಿ ಮೈಕಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅರ್ಥ ಆಗಂಗ್ ನನಗೆ ಏನಾರ ಅರ್ಥ ಆಗುತ್ತೆ. ಮೈಕ್ ಕೆಳಗೆ ಮಾಡಿ. Payment of official benefits. 2003. What matter is it? CRP. CRP is not before me. Must be in the next court. CRP is not before me. Next week. Next week. Monday. Huh? Sweet. Why it's not yesterday? You moved this matter yesterday, day before. Same case. What matter is it? CP. We'll have it on Thursday or Friday. When do you want? Thursday? No, today it will not come. The file has to come. Nodi naale hakagidra. Yes. Who are you?
Here's the response.
Speak. Final hearing you cannot come on scale. Next week. Huh? What's the urgency? What is the urgency? Next week.
Note ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಅದೇ ಆಯ್ತಾರ ಬರ್ತೀನಿ ಅಂತ ಆಯ್ತಾರ ಬರ್ತೀನಿ ಪ್ರಾಮರ್ಸ್ ಅವರು ಟ್ರೈ ಮಾಡೋದಕ್ಕೆ ಮತ್ತೆ ನಾವು ಮಾಡಬೇಕಿದ್ವಿ
Page number 8, number 34 to 36.
Lordships, kindly. Page serial number 36, Your Lordship.
Yes.
It has to be connected with the it has to be posted along with connected matter CP 340 of 2021.
36. You are talking about serial number 36.
Yes, Your Lordship.
Huh?
Serial number 36 CP 88 of 22, Your Lordship.
Madam, yours is 47, madam.
I'm sorry. Sorry.
Registry to list CP 340 for 2021 along with this petition. Call this matter next week.
Page 9, serial number 37 to 46.
By serial number 38, so kindly be 4 weeks back, senior counsel is called to the station.
In which case? Who are you? What is there in the amendment? What is the amendment?
We are providing another petition. So the thing is that court was today, and the case
At request of counsel for petitioner, release this matter after 2 weeks.
Serial number 39, my lord.
What do you are respondent? All right, this is a transfer petition. Why can't you give him? You went to his office. What happened? Why?
one has come to my office.
What copies are not? In transfer petition, all this is filed. You give these papers to him within 2 days. You go to his office and give. You need not go. If he doesn't give, you mention next date. What is this? Be fair. He comes to your office and you chase him out. Respected advocate, respect the advocates. If he's treating like that to you, how you will feel? Give it in 2 days.
Serial number
Yes.
39, my lord. This is a transfer petition regarding MC filed by me. There is already stay order. I have to ascertain the position there in Mysore. Can we have it after 3 weeks, my lord?
All the Shivaram Bhatt.
Yes, my lord.
Stay there.
Stay there. Stay, let it continue. It is my petition actually.
Counsel for respondent release this matter after 3 weeks. Interim stay if any operating is extended till next date of hearing.
Yes.
Page number 10, serial number 48 to 56.
Serial number 55, my lord. Next week at any date.
ಯಾಕೆ ನೀವು ಯಾವ್ದು ಮ್ಯಾಟರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಿಲ್ಲ?
ಆಯ್ತು ಮಾಡ್ತೇನೆ ಸ್ವಾಮಿ. ಇವತ್ತು ಅದು ರೀಚ್ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ ಅಂತ ಡೌಟ್ ಅಷ್ಟೇ ನಮ್ಗೆ.
ಇಲ್ಲ ರೀಚ್ ಮಾಡಿಸ್ತೀನಿ. ರೀಚ್ ಆಗದಿದ್ರೆ
ಮಾಡ್ತೇನೆ.
14 ಮ್ಯಾಟರ್ ಎಲ್ಲ ಫಿನಿಶ್ ಅರ್ಲಿಯರ್.
ಮಾಡ್ತೇನೆ.
Page number 11, serial number 57 to 60. Page 12, serial number 61 to 65. Page 13, 66 and 67.
Your fourth respondent. Your fourth respondent. We inform Karumbaya, counsel for the respondent number 4 submits that there are talks going on between the parties for settlement. Hence, release this matter after 2 weeks.
Page number 14, number 68 to 76.
68. Remember. Release this matter tomorrow. Who are you? Serial number 73 at request of Learned Counsel for petitioner. Release this matter week after next. Interim order, if any, operating. What do you want? In case that request of counsel for a respondent, release this matter week after next.
Page number 15, number 77 to 82.
With kind permission, my lord. 78, serial number 78, my lord. 1 week time may be granted.
Passport matter.
Allah Sami, the land tribunal granted Muda was acquired.
For the petitioner, release this matter week after next.
Please.
Page number 16, number 83 to 85. Page 17, number 86.
Request of counsel for petitioner, release week after next.
My lord, serial number 86, my lord.
Yes,
Yes, my lord. I appear for impleading applicant therein.
week after next.
Yes, my lord.
Page 18, number 87 and 88. Page 19, number 89.
See, there is a carpenter who's disturbing the court. So you want the court to hear you. You use the mic that's provided for you. If you don't want, it's your choice. Really nice. Good. This notice has to go. You're arguing for stay or you want notice? Stay is granted.
Notice to be served on the council tomorrow.
But issue notice to the respondent. Interim stay granted is extended till next day.
Appearing for the petitioner, Lordship. This is a transfer petition filed by the petitioner wife seeking transfer of the MC petition that is filed by the husband, respondent husband, under the Special Marriage Act, under Section 27, subsection 1 B and D to Bangalore, Your Lordship. The petitioner wife is a resident of Bangalore, and the last resident husband and wife at Bangalore, Your Lordship.
So you have not filed anything here?
Yes, it's filed, Your Lordship, and a criminal miss is pending.
Third Learned Counsel for the petitioner. Issue notice to respondent. Learned Counsel is also permitted to take out notice on the counsel representing the respondent before the family court at Mysore. Orders on. Stay of all further proceedings. So till next date of hearing.
Grateful, Lordship.
Lordship, I appear for the petitioner, Lordship. Petitioner is a PG student, Lordship, and in the PG examination, he has scored 197 out of 400, Lordship, in theory papers. In para 5 of the writ petition, in page 4, I have tabulated the marks awarded by the each evaluators. If your Lordship come to the total column, Lordship, petitioner has scored in paper 1 total 205, which average comes to 51.25, and in paper 2 he has scored total 181, average comes to 45.25. Lordship, while considering the result of the petitioner, 2 marks has been deducted from the legitimate marks obtained by the petitioner, Lordship. Lordship, in para page...
total marks you are getting now. What is the total marks percentage? What you are getting now?
Lordship, it is 49.25, Lordship.
All right. Third counsel for the petitioner. Issue notice to respondents. Girish, Sachin. Learned Counsel Girish R. Girish Kumar R is directed to take notice on behalf of respondent, registry to show his name in the cost list, counsel for the petitioner to furnish 2 sets of copy of the writ petition along with annexures. Release this matter week after next.
Oblige, Lordship.
A1 is allowed dispensation of production of original certified copy of annexure held for the time being is granted.
Also acquired the land. The complaint is made by
What is the complaint?
the basis of complaint. What
is it? What is the complaint? What is the complaint?
The complaint is that there are 2 lands which are on. One is survey number 128, which is legend to an extent of 38. It is an additional land which is also owned by the petitioner. The building of this whole is situated in survey number 128, and the other land is vacant. Now the complaint is filed that the other land is vacant, and whereas the building is situated, that land is the documents pertaining to the segment has not been submitted to the department. And where the land is vacant, there is no building segment. That is the allegation submitted. This was that. Upon the petitioner to explain the reason as to why there is no building in the additional extent of land. However, the original land which was owned by the petitioner is measuring for extent of 38 acres. Also, complies with the use for having playground use stipulates for 2,000 square meters annexure G
Yes.
The modification is by the department. The last column DPMP and other municipal corporation areas, 4,000 square meters. This is the prescription of the land. I am owning 38 acres of land. Equivalent to 3,800 square meters. Over and above the extent of land. Now, the only objection which on the list of complaint now the department has issued notice that in the land in question which is owned by the this pool is spent in the land. However, in the land which is leased, additional land there is no land, there is no building of this pool which is situated in the additional land. That is the only objection which they have taken out notice at annexure H 61.
So the annexure L.
Annexure L is the impugned order. Now, Dr. Penny 74. The recognition which was issued in favor of the petitioner has been withdrawn acting under section 39 of the Litigation Act.
Yes, madam, why? 39. Or annexure L. So the property that was mentioned for obtaining is a leased one. It is not built. Instruction is in survey number 128. That is owned by him. According to you, 30 years lease he should have had for the documents which he produced. Now he has put up a construction in survey number 128, which is his own property. To produce those documents. What is the prayer? No, what is your prayer?
Page 73, Manoj. Thereby, Manoj, the recognition Manoj granted in favor of the petitioner Manoj has been withdrawn. A further direction Manoj is issued. Transfer the students Manoj studying in the petitioner further nearby colleges. Manoj, the private response Manoj, I have not read in the party. It is on the basis of this.
Where is your right? Maybe. Sir, are you a party in this case? Then when you are called, you can answer. No, you are not sought for that. You did not say that.
He wants Manoj that all these students studying in petitioner is back for use. And also Manoj to bring it back. Yes, Manoj. The very next time, Manoj, the input order will pass. On sir. And Manoj, this order.
No, I will stay the order. When then you can proceed. If he wants to produce whatever document, you do it. No, now you are now de-recognized. You are not given recognition and asked him to shift. Right? Will you consider that?
Consider this of the complaint, they will not take action so much. Stay this order.
All right, you produce those documents of yours. Mr. Your apprehension that you are going to be disturbed will be taken care. They will not initiate any precipitative action against you. Please understand, sir. I understand your anxiety. You are running a school. Now you treat this as show cause notice. You reply, will grant you 1 month's time. Produce all the documents. You meet the criteria. They will consider it and pass orders.
I make one submission. That issue notice Manoj, I have also submitted this form of order, but this Manoj connection dates. Date 61. Date 61 Manoj, the logic training. This is the Karnataka notice was issued on 3/3/2022.
61.
61 connection. Manoj, I replied to this notice Manoj on page 63 Manoj is the reply. On 6/3 Manoj, within a period of 3 days Manoj, I replied to the notice Manoj. But on 8/3 Manoj, the issue notice passed Manoj. They referred to my reply Manoj, they said Manoj that Uttaravannu sadhyavagide. They said this Manoj and the impute, this is the impute order Manoj which they have passed. This is not Manoj in the form of notice Manoj. Manoj, I will submit all the documents back to the reply Manoj. Let this order be passed Manoj and
Take the third learned counsel for the petitioner. Issue notice to the respondents. Learned AG accepts notice to respondents 1 to 4. Stop. There shall be stay of operation of the implementation of order dated 8/3/2023 passed by the third respondent by annexure L till next date of hearing. No, now that you have issued annexure H, he has replied. No, you issued annexure H. He has replied, producing all documents. You pass an order. That means you have not considered this. All right.
Yes, please. Nothing is to agree. The only grievance is not. Everyone has opened it up for 30 months. Not the rent is where he is running law. There is no permission. The only reason
You have opened the school.
yes,
What is your locus? That will be addressed by government. Your complaint will be addressed by the government. You have no locus. So you are opening a school nearby. Why are you worried? It is between him and the government. Who are you? What is your locus? What is your locus? You are some Robin Hood. Maybe you are not a Robin Hood. What is your locus in this between the government and him? Either government will allow it or reject it. So you have no locus. I will direct you to reconsider. Petitioner. It's a trust established in the year 1963 with the object of running educational institutions. Based on which running a high school in the name of CKS High School, Bhuvanahali, from the year 1963 by obtaining necessary permissions from the state government. The petitioner sought for approval for running the school from the authorities in survey number 128 of Bhuvanahali village, Arsan Taluk. This contention that there are 113 primary school students, 225 high school students studying in the said school. It is contended by learned counsel that the survey number 28 belonging to the petitioner is measuring 38 quintas. The said land is standing in the name of the trust, president of the trust. There is no violation or illegalities committed by the petitioner institution or the trust with regard to the validity of the trust, payment of taxes to the jurisdictional authorities, and other revenue payments. It contains that after securing the necessary permission, petitioner has started to run the school in survey number 128. It's also submitted that in addition to survey number 128, petitioner institution is in possession of an additional extent of land measuring to an extent of 2 acres 4 guntas in survey number 107. 113, 107 bar 12, 13, 15, 17, 18 bar 35. So that's 107 bar so and so on. Along with survey number 108 bar 12, 108 bar 16, 108 bar 8, bar 108 bar 22, 108 bar 28, 108 bar 44. Situated in the same village and same taluk, which is at a distance of 1 kilometer from where the present school is situated and constructed. Less than 1 kilometer. Stop. It is the contention of the petitioner that on the basis of a complaint lodged by one B.E. Shivarame Gowda Kattihalli and K.R. Nataraj Kenchatahalli, third respondent authority issued a show cause notice to the petitioner dated 3/3/23, calling upon the petitioner to furnish reply within 3 days. Full stop. The petitioner replied to the said notice issued by the respondent number 3 on 6/3/2023. Based on the said reply notice, the respondent number, the government, the respondent number 3 authority passed an order on 8/10/2020. Sorry, which is 8/3/2023. That is the order at annexure 8/3/2023, which is the impugned order at annexure L. Thereby de-recognizing, withdrawing the recognition of the petitioner's school for the reasons stated therein in the impugned order. Full stop. Agreed by which the petitioner is before the school. It is content by learned counsel for the petitioner that while obtaining the permission, he had produced the necessary documents with regard to survey number 38. With regard to survey number 128, measuring to an extent of 38 guntas, which is owned by the petitioner trust itself, and another extent of 2 acres 4 guntas, which is taken on lease. And the permission was granted by the respondent authorities to run the school. However, on the basis of the alleged complaint lodged, by the person stated above, the recognition has been withdrawn, which is illegal and contrary to the permission granted by the authorities. It is his contention that the complainants have no manner of right or interest or locus to challenge the permission granted and the consideration of the material placed by the petitioner before the authorities for grant of permission to run the school. With ulterior motive, the complaint is lodged, and succumbing to the pressure of the complainant, the state authorities have withdrawn the recognition of the petitions. On perusal of annexure H and the reply given, it is seen that the petitioner has placed all material documents with regard to him owning the land in survey number 138, measuring to an extent of 38 guntas, and additional 2 acres of 4 guntas of land in the above said survey numbers. Full stop. The issuance of annexure L per se appears to be without any authority and without considering the documents produced by the petitioner in reply to annexure H. Having already granted the permission, the petitioner, the respondent authorities have now withdrawn the recognition without there being any proper reasoning of the consideration of granting permission while the said documents were furnished by the petitioner. Under the circumstances, the submissions put forth by the learned counsel has sufficient force for consideration. Stop. Per contra, learned AG appearing for the respondent's contends that the notice has been issued and the reply given was not satisfactory for the reason that the documents at the time of seeking permission produced was with regard to 2 acres and 4 guntas and above stated survey numbers. But whereas the petitioners running the school in survey number 128 measuring 38 guntas. But all that would pale into insignificance as the permission was granted by the respondent authorities after considering these documents furnished by the petitioner at the initial stage itself. Full stop. However, the state government is at discretion to withdraw the recognition if there is any violation committed by the petitioner or with regard to breach of the conditions stipulated by the state. The circumstances, the impugned order issued at Annexure L deserves to be quashed. Accordingly, it is quashed. It is made clear that the respondent state is at liberty to reconsider the documents which are produced by the petitioner along with the Annexure H and issue proper notice to the respondent, or this can be treated as a notice to the respondent, and respondent may furnish any further documents required, and on providing proper opportunity to the petitioner, the respondent is at liberty to pass fresh orders. This is quashed. You can place any material. If there is violation that you are not running the school where you are supposed to run, they are at liberty to pass it. Accordingly, petition is allowed.
Some objection.
All right, relist this matter tomorrow. Day after tomorrow is not an education day. Monday. Monday you want? All right, permitted. Monday. Take it afterwards. Relist this matter tomorrow at request of the petitioner. What is your? Huh? Learned counsel for the petitioner. See, we are Sarathi submits he has filed wakalat on behalf of petitioner after obtaining NOC from learned counsel Chandrasekhar Yal. Registry to show his name and delete the name of learned counsel Chandrasekhar Yal from the cause list. Petitioner is permitted to carry out certain rectification of the objections. Learned counsel for the petitioner seeks time, 2 weeks granted to do the needful. If needful done, issue notice to respondent. No, whether court notice is gone to respondent. Learned counsel seeks a week's time to comply with the requirements. If needful is done, registry to issue notice to respondent.
My lord, in this case, my lord, I served the copy to the trial court advocate, my lord.
Whether court notice is gone.
A court notice is also served, my lord.
At least notice he ಹೋಗಿರೋದು.
Notice ಹೋಗಿದೆ.
No such person ಅಂತಿದೆ. Take out court notice once again.
Please,
counsel.
Please, my lord, please.
Time is
Entry matter
granted
can be
to
extended, my lord.
take notice to the respondent. Interim order, if any operating, is extended till next date.
Much obliged.
Previous case interim order operating is extended. Was filed IA number 2 of 20. What is that?
Hold on.
2014. Have you filed your objections to this application? Right. What have they said?
Make a master. Cannot right in the office.
All right, let the council come. Pass over. ಸರ್ವಾಗಿ ಜೋರಾಗಿ ಮಾತಾಡಿ ಸರ್. ಕೊಡ್ತೀರಾ? That council to furnish the process fee for issuance of notice to respondents 1 and 3. Weeks time is granted. If needful done, issue notice. R7, you want to retire for R7? Who has filed Wakala? Where has he filed? So Rakesh Bhatt is also on record. Joint Wakalat. His name is there in the Wakalat. What is R7 is some authority?
Discom.
Rakesh Bhatt is here.
R4 and 5, my lord.
Done at council for respondent number 7, Sri G.K. Bhavna. Srina Srimati Nadi Bhavna. Sri andre ನೀವು ನಿಂತಿದ್ದೀರಾ? Where is the Wakalat of Rakesh Bhatt? Discom is a panel. Where is the Wakalat? He is not filed. He is not filed. Rakesh Bhatt is in the panel. registry to show the name, cancel that. Registry to show the name of learned counsel Rakesh B. Bhatt as a counsel appearing for respondent number 7 in the cause list. Yes, what do you want? What is this matter?
It is pertaining to the, my lord, may I submit, my lord?
Any interim orders there? You are now seeking interim order. Are you seeking? What are you arguing for? Yes, Mr. Pottegowda. Rejected. Yaar, impleading application yaro.
My application is rejected and the interim order sought by the respondent of 426 without the Karnataka and
Are you ready in the matter to argue?
My lord, I appear for R4 and 5, my lord. I appear
What
for
do you want?
I want
All right, what do you want?
2 weeks time, my lord.
Learned counsel for the petitioner seeks time. Relist this matter after 2 weeks. Yes. Who are you? The objection is not given to you. A week's time granted to the respondent. R3. R3 to furnish copy of the statement of objections to the petitioner.
In serial number 13, I appear for the petitioner, my lord. I pray for 2 weeks time, my lord.
Granted to comply if needful, done issue notice to R4.
Much obliged, Lord.
The week's time granted to comply if needful, done notice to R8 to 10. Learned counsel for the petitioner is not present. Learned counsel for respondent number 1 to 3 is present before the court, along with the copy of the statement of objections to be furnished to the petitioner. In view of the absence of petitioner, relist this matter week after next. Sebastian.
My lord, I'm petitioner CJ Sebastian. My lord, the objection, I just saw the objection. I did not receive any notification or any communication. I just saw the objection yesterday evening after publishing the course list. That is related to the recent IA published. All the other matters are office objections complied, and it is waiting for last 2 years. Can I be heard today, my lord, for the other matters by not considering the
this IA 1 of 2023 amendment.
Yes, my lord. Amendment is filed on 28th February, my lord.
What is the amendment?
It was a prior amendment. There was a typo. There was a mistake in prior 2, and there was a new prior addition. Everything else is same. If I can be heard.
Copy Kotila. You have to furnish one set of documents of application and other documents which you have given to the state to serial Prasad, Advocate Cyril Prasad.
I have already served the copies, all the copies by email on 28th itself, my lord. 27th and 28th I sent twice.
Yeah, he's not received it. You give it to him.
My
Furnish
lord,
one hard copy.
my lord, it was around 500 pages. So that's why I was sending that.
Give a
by-
hard copy, sir. You can't send 500 pages on email asking him to print everything. Give a hard copy to him.
Sure, my lord.
When will you do that?
I can do that by this Saturday, my lord. Can it be
All
heard on Tuesday, 21st?
All right. Release this matter on 21st at request of 14% Sijo Sebastian. In the meanwhile, he shall furnish the copy of IA number 1 of 2023 along with the documents to the Learned Counsel for respondent number 6.
My lord, I do not have a way to find his address or nothing. All the communications were over email. I had received an email from him, so I was responding to that. Other than that, I do not have his contact number or address.
Other objections come. There are few other objections raised. Comply with that.
Sure, my lord, I'll do that by Saturday.
And when you come to the office, you can take the address of the Learned Counsel for the office.
Sure, my lord.
My lord, I appear for the petitioner in these matters, my lord. This pertains to room surveys. However, my lords, I request this honorable court to grant me a week's time. I'll file an application for amendment of the prayer. And there is one similar matter, my lords, which is also pending. It's serial number 36. I pray for a short accommodation.
Delist. Next week?
Yes.
Along with serial number?
No, my lords. That is there today. If government is ready, my lords, that may be heard. This may be taken up next week, my lords. Whatever happens in that serial number 36, that will follow.
All right, delist next week. Huh? What is this 10 times office objections, madam?
My lords, in the beginning, there were, my lords, because of COVID, this one, we were not allowed to go inside. And at that time, the matters were. I'll also comply, my lords, in a week's time.
Next. Why it will not survive? So that's taken off now. Weeks is granted to rectify the objections. At request of Learned Counsel for petition. Yes, who appears? You're appearing for? You have any objection? Learned counsel for the petitioner files a memo seeking withdrawal, dismissal of the petition as having become infructuous. Memo on submission of learned counsel for the petitioner is placed on record. Petition is dismissed as having become infructuous. Yes. What? Whether you have announced. Whether is there any order of this court not to announce the result? You announce the result. If they pass, they pass. Otherwise, they will. At request of counsel for respondents 1 and 2, revisit this matter after 2 weeks. Weeks time is granted to the petitioner. Comply with the objections. You have an interim order. What is this matter? What is this matter? Course.
Yeah.
So you have granted. Then what is the interim order granted? How many years course is this? Huh? 2 years. All right. Now the petitioners are pursuing which course? All 3. Coming to an end. Interim order ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ರೆ ನಿಮ್ ಪೆಟಿಷನ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರ? All right, you argue the matter. Argue today. You have taken interim order. When is this petition filed? 22. You will finish the course by virtue of interim order. And you want the court to become a party to your illegalities. Next year, yes. H, which one? Which annexure? H. Suppose I hold that is correct. You're ready to argue? Release tomorrow. Leave central government, you should object it. You are the authority who's going to give permission. Admittedly, your order is challenged. So you should be ready to argue the matter. Release next week at request of learned counsel for the respondent.
That's serial number 22 and 20.
Respondent appearing on behalf of the Union of India. Who are you? request of Union of India.
My lord, 22 and 23, my lord, I have done the needful, my lord. Yesterday, I furnished the fresh address,
The
my lord.
counsel for the petitioners submits his then the needful register to verify an order issue notice to respondent.
Interim orders may kindly be extended in both the matters.
Interim order, if any operating, is extended till next date of
Obliged.
in both matters.
Both the matters, my lord, both the matters I have furnished, my lord. Both the matters interim orders have to be extended. 22 and 23.
123.
Obliged.
Which is infectious? It's a similar thing as what in the previous case. Argue the matter on the next week. Relist this matters along with serial number 21. Same Allah. Next week.
Come here, please.
ಕೇಳಿಸ್ತಾವ್ರ ಹೇಳಿದ್ದು ಅವ್ರಿಗೆ ಕೇಳಿಸಲ್ಲ ಇಲ್ಲಿ ಕೇಳಿಸುತ್ತ ಮೈಕ್ ಇದೆ ಅಲ್ಲ ಪಾಸ್ವರ್ಡ್ ನಿಮ್ದು ಸೇಮ್ ಮ್ಯಾಟರ್ ನೀವು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಬೈ ವರ್ಚಿ ಆಫ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಕಾಮಡೇಟ್ ದೆನ್ release this matter tomorrow. Now you are not paid salary. But you are going there. You are going there. Release this matter on Monday. Another counsel submits that he would do the needful during the course of the day. Placing his submission, if needful done, issue notice to respond. This objection. Week's time is granted to rectify the objections. If needful done, issue notice to respondent. 2 weeks time granted, if needful done, issue notice. Then this won't survive. Have any objection? You are a party to that. Huh? Paid. Yeah. Petition is filed by the husband. Yes. So you are challenging the interim order. Another counsel for the petitioner. Notice agila. So this is 29, is it? Oh, sorry. Then counsel for the petitioner submits that the main petition for divorce filed by the respondent wife has been disposed of by the principal senior judge and at Puttur DK in MC number 333 of 2018, which is not disputed by the learned counsel appearing for respondent. In view of the main matter having been disposed of, the present petition would not survive for consideration, which is challenging the application in the main matter, that is MC 33 of 2018. Accordingly, submissions of the learned counsel are placed on record. This petition is dismissed as having become infructuous. Disposal date 19/11/2021. Counsel for the petitioner finds the amended clause title by serving a copy of the same on the other side. Pass over. No representation on behalf of petitioner. List next week.
Hearing for respondent number 3 in the instant matter.
Brilliant. If you want to file reply or statement of objections.
Your Lordship, in the last date of hearing, an interim order was passed against the petitioner, refusing the grant of intake of 60 students for the academic year 22-23. So in the light of this, kindly grant 3 weeks time to file arguments, written arguments to the main writ petition.
Oh, if you succeed in the appeal, you get the order in your favor, then this will have to. My counsel, the respondent seek time to file statement of objections. List we kept the next.
Much obliged, Your Lordship.
Was asked you to execute the bond. Who was asked you to execute the bond? By whom? Our notice to got it. No notice was ordered earlier.
This is a fresh matter. Last week there was another matter.
She notice to respondents 2 and 3. Learned counsel is Learned counsel Sri Girish R. Kumar R. is directed to accept notice for respondent number 2. Registry to show his name in the cost list. Counsel for petitioner to furnish one set of copy of the petition along with documents to the respondent number 2. Have you received, Madam Government? List. AGA for R1. Accepts notice. AGA first argument. AGA for R1 accepts notice for R1. R2 then. Girish Kumar.
Hearing matters 11:34.
Pass over.
Government, officers have executed the lease deed with the government. Copy of the lease deed because it will produce connection fee, based on the 80 units.
What does it matter?
They have issued a notice to me. Okay, if you have entered into a lease, you without taking due course to the project. Yeah. They have anything to do to make it and lease dictates the way the rent must be paid. And in fact, the lease was categorically says that only after 25 years the lessee can hand government. This lease deed was executed pursuant to a government order. The government order passed, approving the lease entered into.
Lease of what?
Vacant land. Now, pursuant to the vacant land was not permission. Now there was a notice. I challenged the said notice. And Honorable had caused the said notice to. Yes, sir. 65 years. One otherwise fell out.
What is annexure A now? For what?
Notice asking me to get the. Conditions are very similar.
What does the lease deed say? You can issue notice and terminate, or you have to go through the provisions of the PP Act? But what does the lease deed contain? What is the termination clause breach?
Lessee should hand over the entire land at the end of the stipulated contract to the department, complete working conditions.
Mr. Madam, you tell me where you are having the powers to just terminate it. You may require it, no doubt. Madam. No. If there is a breach of the conditions of the lease by non-paying the amount or any other breach, where is the eviction order? Where is the eviction order? No, ರದ್ದುಪಡಿಸಲಾಗಿದೆ ಏನು? Lease is cancelled. Where is the order of eviction? Have you initiated? Where does the notice say? Where does it say that the this is governing under the KPP Act? Huh?
KPP Act, there is an agreement.
Does it?
Yeah, this doesn't cover. So the government order was passed. The government order. In fact, at page 25 is the table stipulates the kind of.
You paid.
Yes, that order be passed, an executive order be passed, given otherwise my lords, that I have violated such conditions. So notice to me, they are not meant to follow the kind of violations have carried out.
Okay, do you want to file statement? Better files. Interim order is there? Yeah. Why you argue so much when you have interim order? You could say already order is there, they will even file. Oh, sir. Learned counsel for the petitioner is present. Learned aid HCGP submits that she would file statement of objections. Interim order, if any operating, is extended till next date. File it. We'll list next week.
Mahadevi?
Yes, Madam Akka Mahadevi. Yes, sir. Yes. Tomorrow? Petitioner is a doctor. Petitioner is a doctor.
Rural service matter. A very simple thing is there was no law at all for rural service for these students who have studied government full-time private colleges. They have repeatedly such a stand was taken. They have been contending there is a law. Ultimately, when board directed to producer, they realized that there is no law. Now they have made a law, which is applicable to the students in future according to their own
Prospective.
Therefore, these students cannot be informed with the service. Second thing is under 2015 rules, there are provisions to withhold the certificate, etc. Under this rule, absolutely there is no provision at all for withholding the.
You can argue tomorrow. But we'll have it on Monday. We have interim order.
If interim order is granted, I will not for again.
Rendered rural service.
No, not because.
No, then he will succeed if he is rendered. We don't know whether he has done.
It says that if they don't come forward easily, it will be enforced against them. So far, they have not enforced. 1 year is over. Therefore, whether I have got order or not, they can't inform rural service. Second thing is about 2006 rule.
You are not registered before the. So only after the rural. All right, I'll hear you. You want. So that he is now challenging the aspect of it. All right, we'll have it on Monday. Monday at 2:30 you want? Then at AGS seeks time. This matter on 20th at 2:30. Huh? 31. Absence. All right, just say instead of absence, say a relist next week. Any urgency in this? Next week. Passover. What student is he? There any interim order? Right. 15% attendance if you are giving him permission to write, that means something is wrong with you. Yes. Where is the power to compound? Where is the power to condone that and excuse that shortage of attendance? Is it provided for you? Where is it provided? Which law? Right? That you have to satisfy. If you are satisfied, he is happy to write. Password. When is the exam? Not anytime in the next week. Relist this matter next week. Yeah. That is Mohan Kumar. You have stay.
My lord,
You
I
have
have the,
stay.
I have the respondent.
You're ready?
Ready.
Sir.
Date of marriage is 35.
You're seeking for transfer of OS number 6 from Malur. Huh? Transfer of MC 239. What's the distance?
About 110 kilometers.
Yes, argue.
Around 100 kilometers, correct? And there is no proper bus facility for moving Vastuga to Moga. That was located in para 9 of the correct? The distance between Vastuga to Moga is about 100 kilometers. And there are no direct buses travel. By traveling from Vastuga, the bus at 2 points to reach Moga. And it required 4 hours for one-side journey.
What is this petition filed?
For divorce, and section 31(2) of the Marriage Act. But earlier than the respondent had filed a petition for divorce.
Happened to that?
And then the version was filed in family court of Haryana. But as per Annexure A, based on the but I filed a petition before the Parliament court. Seeking to transfer the
That was allowed, and then Hosadurga petition came to be dismissed.
The appeal came to be disposed of. By giving a wrong address as it was the resident of Kumaga. Now a petition is filed by the respondent before the family court of Kumaga. And I am having the one daughter aged about 11 years.
No, what happened in the appeal?
And after I have heard the copy of the appeal,
I have, sir. What happened? You tell me.
the appeal came to before that, reserving liberty for file a petition under section 31(1), 2, 31(1) and 2 of the Hindu Marriage Act.
31.
13, I'm sorry, 13(1) subclass 2 of the Hindu Marriage Act. And Annexure D.
Whether that order of dismissal was set aside. Then?
Last page is page number 24.
I have 24. Tell me. I have 24. Read it.
Before that, there are page number 23, paragraph 4. In that event, such a petition is made by the appellate hearing before the court. The respondent is the event appellate is what is the point is appeal. Because not only the way of by showing this, the address as is the resident of Yumala.
Who had filed section 9?
I filed the petition for
Was allowed.
No, I'm sorry. The respondent had filed the petition and section before the family court at Harihara. And that came, like, he obtained an ex parte in that. The MC 1 of 2007. Thereafter, the petition was filed before the family court and Harihara under section 31 of that has been transferred by order of
Understand the order of the division bench. Please read that. Who had filed section 9?
Well, I had filed, my lord. Husband's petition. Section 9.
What happened to that petition?
Decreed, my lord. Decreed, and she did not come, my lord. Thereafter, I had to file a petition for divorce.
Then you filed a petition for divorce.
Yes, my lord. So that came to my lord, and thereafter, my lord, MFA was filed. So matter was, my lord, remanded, my lord. A liberty was given, my lord, to me to file fresh petition. In the event of dismissal of this petition, so liberty was also given, my lord, to the respondent.
Dismissal of which petition, liberty? Dismissal of which petition, liberty?
MC number 35 of 2011. MC number 35 of 2011, which was filed by the respondent.
MC number 35 is filed by you for divorce.
Yes, my lord.
That is dismissed.
Yes, my lord. I filed MFA.
That is challenged by you before the division bench.
Yes, my lord.
There is a question of giving you again liberty.
The liberty, my lord, my lord, kindly see, my lord, the order passed by the, my lord, division bench, my lord, in MFA. At para 6, it is needless to say, needless to observe that the dismissal of MC 35 by the impugned order dated 11/12/2000 would not come in the way of consideration of the petition filed by the appellant under section 31(1)(a)(2) of the Act. My lord, thereafter, my lord, it was not dismissed. My lord, the liberty was given to file review petition in the event of dismissal of the petition. Review petition. Yes, my lord.
Where is it stated?
Review of this appeal, para 5. Further, in the event of appellant is unsuccessful in the petition to be filed under section 13(1)(a)(2) of the Act, liberty is reserved to review this appeal. If I am unsuccessful, my lord, I have a liberty, my lord, to review the appeal.
You are already unsuccessful. You are already unsuccessful.
No, now it is pending. So this is the MC petition 239 of 2021. This is the petition.
Which is the petition now?
This is MC.
You have gone and filed one more petition. You have gone and filed one more petition.
Yes, my lord. As well, the directions of the Honorable High Court, my lord, I have filed it under section 13(1)(1) and 2.
Now, what was your earlier petition under which provision?
Under, my lord, cruelty, my lord. 31(1).
When your petition under 13(1)(1)(a) or 1(2) is filed, where is the question of filing another petition?
As per the directions of the Honorable Court, I have liberty is given, my lord. Can you see, my lord, para?
Sir, in the division bench.
Yes, my lord. Division bench itself has granted, my lord.
The court at Harihara was in the divorce.
Don't repeat the same thing.
This appeal, the appellant president being agreed to stop. There is already a judgment for the right passed in next number 1 of
Section 9 of the Hindu Marriage Act, we dispose of this of the reserve liberty to the appellant by the petition under Section 30, 1A, the class 2 of the Act.
Family court, Hindu Marriage Act.
The legal effect of the Honorable Court has extracted the different portion of the provision. Either party to a marriage, whether solemnized before or after, there has been no restriction of causes of right as between the parties to the marriage.
So that is filed now.
Filed under Section 13, 1A.
All right.
That is Annexure D. Right. My submission by showing the wrong address as if the resident of Shimoga, that we subsequent to the marriage unit, and responded, their marriage and life not followed. But the dispute with the parties correct. The petition hearing must roll out of the marriage house.
So now you are resident of. So you want transfer of that matter from Shimoga. Yes. What is your objection?
My lord, the distance is around 100 kilometers, my lord. So there is no, my lord, the difficulty, my lord, to the wife to travel, my lord, from Vasdurga to my lord Shumaga, and that may not be a ground, my lord, for seeking transfer. Only for the distance of 100 kilometers, it is about 1.5 kilometers. And the submission made by the my lord, the
child from the marriage.
I have got a daughter. It is 11 years.
11 years. All right, I'll allow this and transfer the matter.
My lord, may I make one submission, my lord? Lord,
yes.
The presence of the my lord, the respondent may be dispensed with whenever it is necessary, my lord. You will appear, my lord, before this.
Yes. The petition filed. The petition is allowed. The matrimonial proceedings in MC number 239 of 2021 pending before the Principal Judge Family Court at Shimoga, transferred to the Senior Civil Judge at Vasudurga. You have not filed any petition there, Vasudurga. Where is that pending? Is it pending or disposed? In 25 Mugdaital. 127 is. That is pending in which court? We transferred and tried along with the other pending matters before the Senior Civil Judge at Vasudurga. When is the date of hearing? Recovery bid, you know what is 125, what is 127? The execution that will get over after, if you please. Why are you talking about 127? 125 is different from 127. Petition is allowed. Clear.
Madam, may I make one more submission, madam? But since it is an old matter, my lord, is there any direction, madam, for speedy disposal?
Here is the matter.
This is 21, but the litigation is from 2010, my lord.
Then you don't want to put an end. 2011. MC 35 is 2011.
Yes, my lord.
When was this earlier MC filed?
Restitution from 2010.
Don't want to go and stay with your husband. You're for the wife.
Yes, ma'am.
You have not instituted divorce. So you are the wife. Either you stay with your husband or separate. You don't want to stay. You want only maintenance. That you have already filed execution. That you take the process of law. Whether now the question is you want to stay with him or you want divorce. Divorce petition filed by him is dismissed. Restitution filed by him is allowed. You don't want to join him. What is this? Since the initial proceedings filed under section 9 by the respondent husband as of the year 2010 and the divorce petition filed of the year 2011, the learned family judge, the learned judge of the senior civil judge, learned senior civil judge Procedural is directed to dispose of this matter expeditiously. Evidence and a comments are made.
Time limit ಏನದು
expeditiously, and both the parties shall cooperate for speedy disposal of the case. This also the learned senior civil judge is also directed to seek the presence of respondent only when it is necessary. Yes. Yeah, stay. Stay there. Counsel for the petitioner is present. No representation on behalf of respondent. Relist this matter. We kept a next interim stay, if any operating, continues till next date. Which is the other one? All right, list that CP 269 22. List the matter along with this petition next week. Next week.
My Lordship, serial number 42. I'm for the petitioner in this case.
File objections to what?
We feel the IA, my Lordship, for the stay. Video nahi. Video nahi hai. Video nahi hai.
Children are with you. Children are with whom?
Children with nam jote idare swami, petitioner jote idare.
What happened to your video?
Swami on agtilla adu swami. Problem agtide swami. Laptop problem agtide.
Yes. Can you ready to argue?
Swami now ready devi. Petitioner 400 kilometers ಇದೆ swami adu. Monthly twice ಬರೋದು up and down ಮಾಡೋದು ತುಂಬಾ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿದೆ ಅವರಿಗೆ ಅದಕ್ಕೋಸ್ಕರ.
1 minute. ಮಕ್ಕಳೆಲ್ಲಿದ್ದಾರೆ? Now, Your petition is for custody of the children. Children are now in Mangalore. Isn't it better for you to go to Mangalore so that you can even visit the children? That means you are not interested in seeing your children. Right? She cannot travel from there. She's a resident of Mangalore.
The petitioner is a resident of Mangalore, my lordship.
You are resident of Bangalore. He's not here in Bangalore. He is shifted to Mangaluru. You are resident of Bangalore. So from when the children are not with you?
After pandemic, my lordship.
Ogilla. In Bangalore. So what happened in the GNWC? Any interim order granted to them? Or you go and see them there in Mangalore? Want to file no objections? Is there any interim order?
No, my lordship.
But the proceedings are going on.
Yes, my lordship. Monthly twice ಬರ್ಬೇಕಾಗುತ್ತೆ ಸ್ವಾಮಿ 400 kilometers up and down ಇರುತ್ತೆ. Education purpose problem ಆಗ್ತಿದೆ ಸ್ವಾಮಿ ಮಕ್ಕಳಿಗೆ ತುಂಬಾನೇ.
Current counsel for the petitioner. What serial number is this? 42.
Yes, my lordship.
Current counsel for the respondent seeks time to file objections. Orders on IA number 1 of 23 that shall be stayed after the proceedings. You have filed some execution also.
Yes, my lordship. They failed. The respondent failed there.
What execution have you filed? What execution he has filed?
ಅದೇ ಸ್ವಾಮಿ ಸೆಕೆಂಡ್ ಎಂಟ್ರಿ ಅದು ಮಕ್ಕಳನ್ನ ವಿಸಿಟಿಂಗ್ ರೇಟ್ಸ್ ಕೊಡ್ಬೇಕಂತ ಹೇಳಿ ಇದನ್ನ ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಮಂತ್ಲಿ ಟ್ವೈಸ್ ಬರ್ಬೇಕಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಇದು ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ. ಆದ್ರೆ 400 kilometers ಇರೋದ್ರಿಂದ ಬರ್ಲಿಕ್ಕೆ ಆಗ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಎಜುಕೇಶನ್ ಮಕ್ಕಳದು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿದೆ ಸ್ವಾಮಿ. ಇಬ್ರು ಗಂಡು
order. There is the interim order of the court.
Interim order. Page number 22. Page number 37, my lordship.
So, mister, you take the court along with you. You have the page second, you have books put on your page, give the line. Kind of arguments. Page 37.
Yes, my lordship.
Read it. So they have not complied with this order. They have filed execution.
Lordship, ಅದು 400 kilometers ಇದೆ ಸ್ವಾಮಿ. ಮಂತ್ಲಿ ಟ್ವೈಸ್ ಬರ್ಬೇಕಂದ್ರೆ ಮಕ್ಕಳದು ಎಜುಕೇಶನ್ ಸ್ಕೂಲ್ಸ್ ಎಲ್ಲ
Order was passed 20th September. Yes, when did you move to Mangalore?
Pandemic situation only, Swami. Before
Never.
pandemic.
Be specific in your argument, Mr. Counsel. Order is 20th September 2019. When did you move out from Bangalore to Mangalore?
2021.
Your client appears to be very smart and is showing his intelligence. By lock, stock and barrel to Mangalore to defeat the rights of the mother to see the children.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರದ್ದು ಎಜುಕೇಶನ್ ಎಲ್ಲ ಅಲ್ಲೇ ಜಾಬ್ ಇರೋದ್ರಿಂದ ಅವ್ರು ಅಲ್ಲೇ ಮಾಡ್ತಿದ್ದಾರೆ.
I am not staying the order. Proceed with the execution.
400 kilometers ಸ್ವಾಮಿ, ಮಂತ್ಲಿ ಟ್ವೈಸ್ ಬರ್ಬೇಕಾಗುತ್ತೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿದೆ ಮಲರ್ಶಿಪ್.
Your intelligence of your client will be taken care of.
No, ಮಲರ್ಶಿಪ್.
You execute the order. What's next? Issue notice to the respondent. Any interim order was granted? Interim order earlier granted. If any course is extended till next. Now, Mr. Counsel, you have paid the process fee. Registry to verify if process fee paid, issue notice to respond. This your friend Chandrasekhar Reddy. Mr. Reddy, you have to stay. Learned counsel for the petitioner is present. No representation on behalf of this man. We list this matter week after next. Interim stay operating earlier is extended till next date. Shashidhar, no representation on either side. We list next week. There is no representation on behalf of respondent. Counsel for petition is present. We list week after next. Interim order if any operating extended till next date. There was report to mediation. What happened? You are agreeable for transfer. Not settled. Custody petition. So you are seeking transfer from Mysore to Bangalore. Can be allowed. Petition is allowed. Matrimonial the proceedings in GNWC 36 of 2021. Pending on the file of second additional principal family court at Mysuru. Is ordered to be transferred to second additional principal judge family court of Bangalore. Anything is pending in Bangalore? To be tried along with criminal miscellaneous number 125. 711 of 2019. Yes. Review of this post. Your disposal IA number 2 for direction would not suffice. Stands consigned to records. Yeah, Shokumar Shetty. You have a stay? Current counsel for the petitioner is present. No representation on behalf of respondent. Interim stay is extended till next date. Relist after 2 weeks.
Serial number 50, I represent the petitioner, my lord. This is wife's petition. Lord, seeking transfer of divorce proceedings from Bangalore court to Hassan court.
Your friend has saved the time of your argument.
Please, my lord. Please, my lord.
Save the energy.
Please, my lord.
Shall I say with consent or you want objection a court order? Court order. No. Your consent you want me to record or a court order? Petition. Petition is allowed. The matrimonial proceedings in MC 2372 of 22 in the file of 6th Additional Principal Judge Family Court, Bangalore, is ordered to be transferred to the family court. Family court, the Hassan.
Please, my lord. There is a family court at Hassan.
Any petition is there pending? Which
Lord,
one?
a CMIS case is pending before the family court at Hassan. CMIS number 28 of 2022.
Family court at Hassan to be tried along with criminal miscellaneous 28 of 2022 pending between the same parties. Full stop. Since the matter is listed on 25th March, parties are directed to appear before the family court on 25th March 2023 without awaiting any further notice.
Please, my lord.
Madam, objections are the paragraph. Payment contention of so-and-so, objecting to the transfer on the ground. It's a frivolous petition and the distance is not much.
Sorry, distance is same.
Maybe, but she's a resident of. The resident of Hassan. Maybe. The judgment says the convenience of the wife has to be looked at. If she was not resident of Hassan and somewhere else, then it would have made it, your argument is sustainable. Because now that she may have to go back to her maternal parents must be at Hassan. Okay, parents must be at Hassan. Transfer it to us. Distance is not much, only a few kilometers up and down. Anything is pending in Hassan? And the petition is allowed. Matrimonial proceedings in MC numbers 226 of 22, pending on the file of First Additional Principal Judge Family Court at Mangaluru, is ordered to be transferred to the Principal Judge Family Court at Hassan. Stop. It's a vehement contention of learned counsel for the respondent that the distance from that the petitioner wife is presently working in Gadag as a doctor, junior resident psychiatry department, which is evident in the first title described by the petitioner herself. Therefore, if she has to travel from Gadag to Hassan, the distance is 388 kilometers, whereas Gadag to Mangalore is 418. Therefore, she might as well travel from Gadag to Mangalore instead of Gadag to Hassan. As either way, she will have to travel to attend the court proceedings at Mangalore or at Hassan, since she is not residing in Hassan and she is presently residing in Gadag and working as a junior resident. Having considered the same, the fact remains that the petitioner is a permanent resident of Hassan and her parents are residing at Hassan. Hence, it would be in the interest of the petitioner, being a lady, and the convenience would be to transfer the matter to Hassan rather than to Mangalore. There will be less hardship and inconvenience caused to the respondent husband in traveling from Mangalore to Hassan and from Neo Doctor. So you have longer distance to travel. Different state. All right. So you are also not in Mangalore. But you are a resident of? And it is submitted by Learned Counsel for the respondent that he is also not a resident of Mangalore. Though he is a permanent resident of Mangalore, he is working at Thiruvananthapuram as a doctor in the government medical college. Okay, Dr. Singh Madkondring, you didn't try for settlement or mediation. Deferred. What is your expertise? Gastroenterology. Auro? Psychiatry, no? Sorry. Gastroenterology and psychiatry. All right. But you should have realized before marrying a psychiatrist. All the petition is allowed. Anish, no representation on behalf of petitioner, whether counsel for respondent is present.
My lord, pardon me, my lord. I am appearing for the petitioner in serial number 52, please, my lord. Pardon my delay. My lord, I appear for the petitioner wife, please, my lord.
Yes.
My lord, the wife has preferred the petition seeking transfer of the divorce petition filed by the respondent before the Honorable First Additional Principal Family Court, Bangalore, please, my lord. My lord, prior to this, the petition, the respondent herein had instituted another petition, please, my lord, MC 643 of 2019, please, my lord. The judgment is at page 71 to 90, annexure D, please, my lord. And the respondent had instituted that petition before the Honorable Family Courts of Mysore, please, my lord. The said petition was under section 9 of the Hindu Marriage Act, please, my lord. And the same came to be dismissed by the respondent, please, my lord. Yes, please.
Dismissed.
Thereafter, my lord, several petitions for the execution of the interim pendant light, maintenance pendant light came to be filed, and thereafter right now a petition instituted by the petitioner herein under section 125 of the Criminal Procedure Code is pending on the file of the Honorable 4th Additional Family Court, Mysore, please, my lord. And that can be found in Annexure G, please, my lord. Pages 114 to 131, please, my lord. The order sheet and the petition in Annexure H, please, my lord. Now, after filing of the same, the present MC petition, that is 5028 of 2022, has been instituted by the respondent at Bangalore, please, my lord.
For what?
Seeking dissolution of the marriage, please, my lord. So presently there are 2 petitions pending before the Honorable Family Court of Mysore, 4th Additional Family Court of Mysore, please, my lord. That is Criminal Miscellaneous 70 of 2020 and Execution Petition 12 of 2022, please, my lord. The respondent has only filed the present case so that the petitioner may be harassed by running from pillar to post, please, my lord. The interim maintenance awarded in the MC petition still stands unpaid, please, my lord. 2 successive execution petitions were filed. 1 was satisfied. The second is still pending, please, my lord.
2 successive
execution petitions were filed, please, my lord, seeking execution of the orders of maintenance pendant light, please, my lord, which was not paid by the respondent. Presently, there is 1 petition pending, and that in that petition also the petitioner herein was constrained to seek salary attachment, please, my lord, because he is not coming upfront and paying any pendant light.
Already you argue on merits of this case for transfer. Why are you arguing on maintenance?
My lord, all these matters are still pending before the honorable courts in Mysore, please, my lord. So execution 12 of 2020, 22 at Annexure E, please, my lord. I produced the order sheet, and Annexure F is the copy of the entire petition, is still pending, please, my lord. And criminal miss number 70 of 2022 at Annexure G, the order sheet is being produced, and Annexure H is the petition. Both are still pending, please, my lord. Subsequently, MC 5028 of 2022 has been instituted before the Honorable First Additional Family Court at Bangalore. I am seeking transfer of the Bangalore petition before the courts in Mysore so that all of them may be heard together, please, my lord.
On what ground your petition came to be rejected?
Pardon me, my lord. The respondent had preferred the petition, please, my lord. That came to be rejected.
So you have finished your argument. You listen to your friend. Speak on the mic so that you can hear it.
Right hand.
So whether they have made allegations that you demanded dowry? File ಮಾಡಿದ್ದಾರೆ. So you are a resident of Mysore. You, your client. So now you are also a resident of Bangalore. You should say it may be transferred. You are residing in Bangalore. What's the difficulty for you? ಹೌದು ಅವರು ಬ್ಯಾಂಗ್ಳೂರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೇಳ್ತಾ ಇದ್ದಾರಾ? You are a resident of Bangalore Earlier you were in Mysore. All right. Now the petitioner is in Mysore. So you are going to attend those two cases there. You transfer it to Mysore. Of course, petition is allowed. Matrimonial proceedings in MC 5028 of 22 pending on the file of first additional judge, family court at Bangalore, is transferred to the fourth additional principal judge, family court at Mysore to be tried, along with miscellaneous 70 of 2020. That criminal miscellaneous is pending in fourth additional court.
Yes, my lord. Along with execution 12/22, both are pending before the fourth additional court, please.
Along with the criminal miscellaneous 70 and execution 12 of 20. When is the next date of hearing there?
My lord, pardon me, I do not appear for the petitioner therein, please, my lord.
Hello.
Much obliged.
Behalf of? What's your name? Venkatesh? Subbareddy. Somareddy. Learned Counsel Venkatesh Somareddy undertakes to appear and file wakalat on behalf of appellant. Is permitted to do so. Registry to show his name in the cost list as counsel for appellant. Yes, Mr. Mahesh.
Yes.
You are ready? Ready?
Lord, the council has to, my lord, think. Mr. Hegde is.
I'm asking him whether he's ready.
Oh, please.
Huh? Thursday. Did you do it next week?
Please.
Ready. Learner, one nimsha. Learner Counsel Sri O Mahesh is present to video conference. So liability is on you, Mr. Mahesh?
Lord, I didn't check my similar because I thought that it may not.
The owner is dispensed, so liability must be on you.
Okay, maybe.
So anyway, you are not preferred appeal.
No, I am not preferred.
Read this next week. Where is Subramania? Who are you? So against the owner. Who's owner? Anyway, they are not before the court. They are not before the court. Hello? They are not challenged. Whether fastening of liability against 1 and 2 is correct. Then how you can make both liable? So I am asking you as an officer of court whether such an order is correct. Learned counsel for the appellant is present. No representation on behalf of respondents. Relist next week. Shastriji.
Yes, madam, I am ready, madam.
Mahesh.
Yes, madam.
Madam, on 2 counts, madam, I filed the appeal. One is on quantum, and another is on negligence, madam. Madam, the appellant was riding his motorcycle, and the vehicle belonged to respondent came and dashed at the junction. Accident occurred in the junction. But while deciding the question of negligence on issue number 1, tribunal come to the conclusion that the accident occurred because of rash and negligent driving of the respondent's vehicle. That is found in page number 7, page number 6 in the Stat Act, issue number 1. Accordingly, issue number 1 answered in the affirmative. So the issue is
charge sheet is also filed against the
against correspondence vehicle, my lord.
Ah.
Thereafter, my lord, the tribunal, on the ground that the rider, that is the appellant, was produced the driving license, which shows he was eligible to drive the car, that is the LMV. My lord, that is why 25% of negligence straight away put on the claimant, which is not at all correct. My lord, that is found in page number 12, para number 12 of the judgment. There is no other appreciation. Merely because the driving license produced to show that the appellant was riding the two-wheeler, but the driving license shows he has driving license to drive LMV. Only on that count, without appreciating other facts and forgetting the issue number 1 is decided in my favor. Straight away, 25% of the negligence is foisted on the claim.
Driving license of what?
Car.
You are riding a motorcycle.
Yes. The production of driving license is nothing to do with the negligence aspect. That is Sudhakaran case, several cases is there. That is why that finding.
No charge sheet is filed against you.
No charge sheet. No charge sheet is filed. So it is the first point. Even though as far as quantum is concerned, accident is of the year 2013. He was a driver. Professionally, he is a driver.
Age?
My lord, age is 27. My lord, since I have no case on pain and suffering.
What's the disability?
Disability 14% whole body, 41% limb, 14% whole body.
The evidence is there.
Doctor evidence. Dr. PW, who is the doctor?
Records either 40%.
What 14%.
14% to what?
Whole body, 41% to limb. 41% to limb.
Which limb?
41% to left and right, both is left ulnar and left forearm. Upper limb is 41% to whole body 14%. The evidence on record shows up to the date of accident, he was working as a driver in a private company, drawing salary.
What have you produced to show he was working as driver?
Salary certificate has been produced, but I am not relying upon that document because I am not able to let the evidence of the owner. That's why.
How much is that?
8,000.
ST the salary.
8,000. Other prakar 9,000 agate. Ega 8,000 takolbo swami as per this legal service chart. 2013 mein.
8,000. You are not examined the author.
Author of that, my salary certificate is not examined, Melad, the 50,000 globally awarded on the loss of earning capacity. Out of these multiplier method amount, Melad, this 50,000 is required to be deducted.
Sorry, what is that? 15,000?
50,000 awarded towards disability. Globally. That is to be deducted in this head. That is, if 14% is considered, Melad, it comes to 1,120 into 12 into 17. It comes to 2,28,480. Out of that, this 50% is required to be deducted. May I come to the other heads which I am entitled? As far as the pain and suffering is concerned, the tribunal is very generous to grant 1 lakh rupees on this count. So I have no case on that point. I am not urging that point. loss of amenities. Well, if comminuted fracture of both the bones of left forearm, fracture of left ulnar styloid at wrist level. Well, for this injury, well, he underwent surgery. Well, 1 lakh is awarded. Well, it is just and reasonable. But loss of amenities, well, no compensation is awarded. And the loss medical and incidental expenses, well, reasonably awarded. Loss of earning for the laid up period, well, no compensation is awarded. Future medical expense 15,000 ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು it is left to the court. 25,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್. It is still in situ 45,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಯಾರು ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ? ಡಾಕ್ಟರ್
ಹೇಳಿದ್ದಾರೆ 45,000 ರಿಮೂವಲ್ ಮತ್ತು ಅದರ್ ಸರ್ಜರಿ ಬೇಕಾಗ್ತದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು 15,000 ಕೊಟ್ಟಿದ್ದಾರೆ. It is left to the court. And so, conclusion, my argument, that is, this contributory negligence is to be set aside. First point. Second point, yes. I am entitled under 3 major heads: for loss of future earning, yes, and earning capacity, loss of amenities, and loss of earning for the laid up period. These 3 heads is to be compensated.
Yes, sir. Mahesh.
Yes, Lord. Lord, he was holding a license for a 4-wheeler, Lord, LME. That doesn't mean, my Lord, that he can ride a cycle or a motorcycle, a 2-wheeler.
Cycle license.
My uncle was there, he was driving the car, but he was not able to ride even a cycle. So, therefore, it can't be presumed that having a LME, he can ride a 2-wheeler.
But there is no charge sheet or FIR against him.
No, I am not, my Lord. The facts of the case, my Lord.
Even agreeing with your argument, yes, I understand and I agree with you.
Yes.
That there is no provision now, or
now
to write
Exhibit P3 and Exhibit P4, IME report. On question of my Lord, it's at the junction. We have to wait and proceed. Exhibit P3 rough sketch may kindly be looked into.
Yes, yes.
Yeah.
Yes.
Yeah. But that indicates, my Lord, that he being a driver of my Lord, a 4-wheeler, knows the, my Lord, the rules of, my Lord, and regulations of the road. He was, my Lord, this thing waited to pass the, my Lord, the other vehicle to this thing. Then, therefore, then IME report, my Lord, will give the, my Lord, indication in respect of damages caused to the respective vehicles. Therefore, cumulatively, my Lord, 25% contributory negligence held by the tribunal does not require to be disturbed.
Yes.
Yes. Then, my Lord, the tribunal, my Lord, has granted 1 lakh, my Lord, for pain and suffering, 50,000 future medical expenses, 75%. Again, my Lord, medical expenses, and 50% loss of amenities. Lord, kindly see, he has not produced his driving license. There is no evidence that he has suffered a disability so that he cannot drive in future. Driving license is not produced. Driving license is not surrendered. Driving license, my Lord, will be renewed only if he is medically fit. That, my Lord, evidence is not forthcoming. Therefore, my Lord, the tribunal thought it fit in the circumstances, my Lord, 1 lakh to the pain and suffering, that which is, my Lord, as on the higher side, will take care of, my Lord, the loss of earning capacity also. That was on the mind of the tribunal. 50% future medical expenses is on the higher side.
Future medical expenses. Future medical expenses.
I get corrected, Mr. Shastri, please.
15,000 ಅನ್ಕೊಂಡ್ ನನ್ನ Future medical expense 15,000. 50,000 is on the other head. That is a disability and put.
So 50,000 loss of amenities of life, 75,000 medical expenses, 50,000 future medical expenses. That's what I have made a note. I'll stand corrected if you can.
No, 50,000 is given because of disability.
Disability.
Because no disability is awarded.
No.
Removal of implants, 15,000. Medical bills, 75,000.
75,000.
1 lakh rupees, pain and suffering.
Yes. I put page 9, my lord, that you see.
9, correct.
So my respectful submission, my lord, in view of the, my lord, the facts and circumstances of the case, the award made by the, my lord, tribunal is reasonable. He has not produced any evidence to show that because of that injury alleged to have sustained by him, his loss of earning capacity has resulted because he has not surrendered his driving license. He has not even produced the driving license for four-wheeler. Looking into, my lord, exhibit P3 rough sketch and exhibit P4 IME report, that gives a clear indication, my lord, the negligence on the part of the, my lord, the injured.
Stitch it, how to read it? Stitch it in such a way that we can read it.
Issue number 1, will of my kindly see, my lord. I'll read issue number 1, my lord.
What is your cross-examination against the doctor?
No, regarding the, my lord, manner of accident.
That you can't have now a qualm with it because there is no FIR or charge sheet filed against the petitioner.
Let
Your
that,
argument.
let that mere filing of a charge sheet, my lord, will not, my lord, I mean, conclusively prove the negligence.
All right, you show in your evidence cross-examination of PW1.
But the narration,
What have you elicited? Whether he has
the
accepted?
manner in which the accident occurred itself, my lord, the court has preponderance and probabilities, irrespective of, my lord, the charge sheet. Charge sheet will always be filed, my lord, against a bigger vehicle. So that is not an encyclopedia, my lord, but the tribunal has to decide on the facts and circumstances of the case.
Yes.
Yes. Therefore, my lord, there is no, my lord, reason to disturb the finding of the tribunal, my lord, on question of contributing negligence.
Please read cross-examination of PW1.
Yes. PW1, it is an interested testimony of PW1, my lord.
Wait, you have to bring it and drill it into the witness to adduce evidence.
Yes. Rough sketch and IME report, my lord. Undisputed.
First you read PW1 cross-examination. We'll come to the sketch later on.
But I am not disputing that, my lord. What I am trying to canvass before your lordship is whether there is a cross-examination or no cross-examination. The material, my lord, the rough sketch and the, my lord, the IME report speak for themselves.
All right. So you are not disputing the cross-examination or evidence of PW1 and 2?
But even thinking, my lord, that there is no cross-examination. I will go to the extent of saying that no cross-examination, but the documents, my lord, placed by the, my lord, the claimant exhibit P3 and P4, preponderance and probabilities has to be, my lord, considered by the appellate court. As
All
well
right.
as
The police has not registered any case against him because even despite a P3 spot sketch, which according to you shows the negligence
yes,
of the
filing of charge sheet itself is not a proof of negligence.
All right. What have you done?
But I am not
Have you challenged it?
Yes, my lord, because the problem is, my lord, there are no complaints of section 134C and 158(6) by the investigating officer.
All right. Have you filed any complaint that I was not at wrong, he was
But
at wrong?
I only came to know when I received a claim notice by the tribunal, But
About you
134C.
means insured. You means insured.
Insured. 134C, 158(6) by the jurisdictional police. They have to supply the copies to the insurer. That is not done. In all these cases, my lord, this is the problem. Mere filing of the charge sheet, my lord, suppose, my lord, if he is acquitted, they say that it is interesting, but tribunal has to decide independently. Even, my lord, if any material place that the driver who has been charge sheeted has been acquitted. Therefore, negligence, my lord, has to be independently, my lord, has to be assessed by the tribunal and the appellate. Therefore, my lord, my submission to your
You
lordship.
now prove it that he is negligent. You now establish by documents which is placed before the tribunal that he is negligent.
Therefore, my lord, my submission was preponderance and probabilities in the light of exhibit P3 and P4.
Yes.
Yeah.
Yes, I am having P3 and P4.
Yes.
Tell me.
Therefore, the reasoning of the tribunal that he was negligent and he was not having a license for a two-wheeler. Doesn't know whether he can balance a two-wheeler properly. So even if he violated the law, it can't be, my lord, sympathize with him. A four-wheeler driver, my lord, cannot even able to drive a cycle apart from motorcycle.
So he is not asking sympathy. He wants to, by the rule of law, on the proceedings.
No, that's what, my lord, I am saying. That's the reason, my lord. Maybe he was not conversant with riding the, my lord, two-wheeler and caused the accident. And, my lord, so far as, my lord, the loss of earning capacity, he has not proved. His driving license is not surrendered. His driving license is not produced. However, the tribunal, my lord, with a liberal this thing, my lord, 1 lakh for pain and suffering and other heads are reasonable. Therefore, my submission is that does not require, my lord, any interference. 8% interest, my lord, is on the higher side, which is very good.
Interest.
Yeah, that will take care of
interest 6% enhanced amount. I am entitled only 6% for enhanced amount.
What I am submitting 8%, what has been granted, you will take care of other aspects.
All right. Good. That's all, sir?
Yes.
All. This appeal is preferred by the claimant. Being agreed by the impugned judgment award passed by the motor 8th additional small causes judge motor accidents claims tribunal at Bangalore. MVC Madam passed MVC 2629 of 2013 dated 1st April 2014. This appeal is proposed on the ground of meager and inadequate compensation awarded by the tribunal. Stop. Brief facts of the case. It is the vehement contention of the blank. It's a vehement contention of learned counsel appearing for the claimant that the tribunal has committed a gross error in not awarding just and reasonable compensation, and does not cite of the fact with regard to awarding of compensation on the ground of disability, and also has committed serious error in attributing contributory negligence on the petitioner, claimant, the petitioner, but claimant. He also, learned counsel further contends that the tribunal has committed an error in looking at the aspect of the spot sketch and attributing contributory negligence against the claimant. Further, a gross error has been committed by the tribunal on the ground of the claimant not possessing a valid and effective driving license to drive a motorcycle, whereas he was possessing driving license for driving a light motor vehicle. On these grounds and on the ground of inadequate and meager compensation under other heads, claimant is before this court seeking enhancement of compensation. Full stop. Per contra, learned counsel appearing representing the insurance company vehemently contends that there is no error or material irregularity committed by the tribunal in awarding compensation to the claimant. Further contends that the tribunal is right in awarding just and reasonable compensation, and the tribunal has not committed any error in attributing 25% contributory negligence to the claimant for the reason that the claimant did not possess a valid and effective license to ride a two-wheeler merely because he possesses a license of a four-wheeler, that is LMV. It would not be a deeming provision or infer the fact that the claimant would have the knowledge to ride a motorcycle. Full stop. He learned counsel O. Mahesh further contends that the tribunal is justified in not awarding any amount towards disability and for loss of earning capacity for the reason that the claimant has not produced any material before the court to show that due to the accident, he is encountered disability wherein there is a loss of future earning capacity. In view of non-production of such material, the question of awarding any compensation for the loss of future earning capacity due to disability would not arise. Full stop. The counsel also contends that in a case of claim for compensation in motor accident cases, the tribunal and this court will have to look into the aspect of preponderance of probabilities and also the police records and medical records produced by the claimant to assess a just and reasonable compensation, which cannot be a luxury to the claimant, but which will have to be just and reasonable, commensurate to the injuries suffered by the claimant. On these grounds, he seeks to dismiss the appeal and affirm the order passed by the tribunal. He also contends that the tribunal has exceeded its jurisdiction in awarding 8% interest, which is not contemplated under the Motor Vehicles Act or under the Code of Civil Procedure. Therefore, the award of interest is also on the higher side. On these grounds, he seeks dismissal of the having heard the learned counsel for both parties, point that arises for consideration before this court is whether, point 1, claimant is entitled to enhancement of compensation. Point 2, what order? It is not in dispute, Param, that the accident occurred on 24/4/2013 at 9:30 p.m. when the claimant was moving on his motorbike bearing number KA01EY5618 on JP Nagar 9th Cross Junction, during which time an auto rickshaw bearing KA05AA1009 came in a rash and negligent manner and dashed against the two-wheeler which the claimant was moving. Full stop. The occurrence of accident, involvement of the two vehicles stated above, injuries sustained by the claimant are all not seriously disputed. The registration of FIR, charge sheet being filed against the driver of the offending vehicle are also not disputed, and so also it is not challenged by the driver of the said vehicle, offending vehicle. It is also seen that the insurance company or the owner of the offending vehicle are not in appeal before this court. The claimant has challenged the impugned judgment and award seeking enhancement of compensation. In view of the fact that there is no serious dispute with regard to occurrence of accident, involvement of vehicle, and the injuries sustained, this court will have to consider the quantum to be awarded. Stop. Coming to the aspect of age avocation income of claimant. Though the claimant has stated that he was working as a driver, earning an income of rupees 9,000 per month, nothing material has been placed before the court to establish the same. In view of no material evidence placed with regard to proof of income, though the salary certificate is placed at Exhibit B10, the author of the said document having not been examined, same cannot be taken for consideration. However, the accident having occurred in the year 2013, the notional income chart for the said period describes 8,000 rupees per month as income. Same is to be taken as income of the claimant for assessment of compensation. Full stop. Claimant has got examined PW2, the doctor who has adduced evidence for the court, stepping into the witness box and has narrated the injuries suffered by the claimant, and he has stated that the claimant has suffered injuries and encountered a disability to an extent of 41% to the left upper limb and 14% to the whole body. Full stop. However, the tribunal has negated this aspect of providing any disability benefit and compensation to that effect on the ground that no cogent material has been placed. However, it is to be seen that the evidence of doctor has been ignored by the tribunal who has adduced evidence. Nothing cogent has been elicited in the cross-examination of the doctor with regard to the veracity of the opinion expressed by the doctor, and neither is any contra material placed by the insurance company with regard to there being no disability and that he is working in the same manner without any reduction of his earning capacity. In view of the evidence of the doctor who is an expert expressing disability to an extent of 14% to the whole body, the tribunal cannot sit over the opinion expressed by the expert, getting into the armchair of the expert to disbelieve the statement made by the doctor unless contra material is placed or contra evidence is elicited in the cross-examination of the doctor or PW1, the claimant. This being not the case of the insurance company and no material having been produced, the disability assessed by the doctor of 14% for future earning capacity will have to be taken for consideration. Accordingly, disability is assessed at 14% is accepted, to be accepted. Full stop. Claimant being aged to 27 years.
But he has not surrendered the driving license. He has not produced any material, my lord.
With regard to?
Loss of earning capacity, future earning capacity, my lord. If he is not medically fit, my lord, then the driving license will not be renewed, or he should have surrendered the driving license. There is no material. Therefore, in the absence of that, my lord, no computation can be made, my lord, on a presumptive.
Internet counsel for the insurance company also contends that he has not surrendered, the claimant has not surrendered his driving license to show that he's become incapable and encountered disability and is unable to drive the vehicle anymore. In the absence of such document of having been produced, this court cannot assume that the claimant has become disabled and consequently awarding any compensation to that effect. I'm afraid this contention of the counsel for the appellate respondent insurance company cannot be accepted. Even if the claimant has not surrendered his driving license, the same would not infer or prove the fact that he has not suffered any disability, which would hamper his driving capacity to drive the vehicle or do any activity in the same manner as he was able to do prior to the occurrence of the accident. Claimant being aged 27 years, the appropriate multiplier applicable in the present case would be 17. For consideration of the future loss of future earning capacity due to disability, 17 is the appropriate multiplier. The income being taken as 8,000, the loss of future earning capacity due to disability would be 8,000 into 12 into 17 into 14%. 2,44,800. Full stop. Para. The claimant has produced medical bills to the tune of, as per Exhibit P12, and the tribunal is awarded a sum of rupees 75,000 towards medical bills. Same is not interfered. For removal of implants, the doctor has stated on oath that 40,000 is required. Tribunal is awarded 15,000. I am of the opinion that same is on the lower side. However, 40,000 cannot be awarded. 30,000 is a reasonable amount to be awarded under this head. The tribunal is awarded an amount of rupees 50,000 towards disability, which has already been addressed by this court by awarding loss of earning capacity towards disability. Hence, this amount is adjusted towards loss of earning capacity as discussed above. The tribunal is awarded an amount of rupees 1 lakh towards pain and suffering. Considering the fact that the tribunal has not gone into the aspect of awarding disability, the said amount is awarded. In view of this court awarding disability due to the compensation due to loss of earning capacity, the said amount is reduced from 1 lakh to rupees 50,000.
$1 lakh. ಇದರಲ್ಲಿ ಫ್ಯೂಚರ್ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ 2,28,000 and 50,000 ರೆಡ್ಯೂಸ್ ಮಾಡಬೇಕು.
ಯಾವ್ದ್ರಲ್ಲಿ? ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್.
ಅದಕ್ಕೆ ಲಾಸ್ ಆಫ್
pain and suffering 1 lakh is given by the tribunal on the ground that you are not being given disability. So that is because you are now encountered only fracture.
ಹೌದು ಸರ್. ಸರಿ. ಇದಕ್ಕೆ ಲಾಸ್ ಆಫ್ ಎಮ್ಯುನಿಟೀಸ್ ಅದು ಕರೆಕ್ಟ್ ಆಗ್ತದೆ.
Tribunal has not awarded any amount towards loss of amenities and towards loss of income during later period. Towards loss of amenities, 25,000 is awarded. Towards the later period, in view of this court assessing the income to be 8,000 rupees per month. What is the fracture you are income? What is the fracture?
Two major fracture, comminuted fracture of both the bones of left forearm.
4 month period would be required for recuperation and getting back to his normal day-to-day activities. 8,000 into 4, 32,000 is awarded under this head. Full stop. Coming to the aspect of the tribunal awarding, attributing contributory negligence of 25% against the claimant. That the basis of attributing 25% contributory negligence is on the ground that the claimant was not possessing a valid and effective driving license to ride a motorcycle. The driving license to drive a light motor vehicle. Be that as it may, unless it is proved by the insurance company or the owner before the tribunal or before this court that the accident has occurred due to the act or negligence of the claimant, contributory negligence cannot be attributed merely for non-possessing of a valid and effective driving license, which is well established in several catena of judgments of this court and the apex court. Therefore, attribution of 25% of contributory negligence as against the claimant is arbitrary and perverse, and the same is set aside. In view of the discussions made here and above, one more per ayatma. Learned counsel has argued, for the insurance company has argued that the interest awarded by the tribunal is on the higher side, but however, there is no appeal preferred by the insurance company. But nevertheless, the enhanced compensation shall be paid at the interest of 6%. Full stop. In view of the discussions above, the claimant is entitled to total compensation of 4,56,800 as against 1,80,000. The said compensation shall not carry interest for the future medical expenses of rupees 30,000 awarded by this court. Full stop. The judgment and the appeal is partly allowed. The judgment and award passed by the tribunal is modified. Claimant is entitled to total compensation of dash as against 1,80,000. The interest of 8% are awarded by the tribunal is retained with regard to future, with regard to enhanced compensation. The claimant would be entitled to interest at 6%. Stop. The entire compensation amount shall be deposited from the date of claim petition till realization before the jurisdictional tribunal within a period of 6 weeks from the date of receipt of copy of this order.
Please.
Sweet Mr. Mahesh.
Yes.
Deepa Shastri wanted adjournment in the matter in the morning.
I don't know his calculations, my lord.
His calculation is wrong. Your calculation is right. So he owes you a treat for this. He argued the matter. Shastrigalu ಹೊರಟುಬಿಟ್ಟಿದ್ದಾರೆ. Yes. All right. Serial number 9 released next week. Objections overruled. As same is complied. When? Yavaga? 87. Serial number 87 at request of counsel for the petition released on Monday. Serial number, registry to list below mentioned matters along with this appeal released next week. Serial number 60 at request of learned counsel for the released next. What do you want? Why? Request of counsel for the petition relist next week. Serial number 57 at request of learned counsel for respondent number 2, relist next week.
Milord, serial number 83 and 84 maybe. Milord, serial number 83 may be listed in the next week, Milord.
Why? Why, madam?
My lord, there is a memo that was filed by the counsel for respondent number 4, and I have filed my objection on that, my lord. It may be listed for hearing on the memo. The memo was filed for clubbing of the matters, my lord.
Who are you appearing for?
I am appearing for the petitioner, my lord.
Serial number 83 at request of counsel for petitioner. 80?
83, my lord, 83. I may be heard on the memo, my lord.
Request relist next week. Yes.
Much obliged.
Lord, may I make a submission, my lord?
Yes.
My lord, serial number 77 may kindly be dismissed as become infectious, my lord.
Family court matter is disposed of.
Please, my lord.
Your petitioner.
Please, my lord. I am for the petitioner.
Learned counsel for the petitioners present through video conferencing. He submits that the main matter for the family court has been disposed of. Quite order dated.
My lord, in the year 2020, my lord, it was dismissed.
In the year 2020, as the present writ petition challenging the interim order of the said petition would not survive for consideration. Placing his submission on record, this petition is dismissed as having become infructuous.
Much obliged, my lord.
Also, one said, I will take not that I am waiting over my time. Lord, you have made submission for number 18. Last better.
With fine. Tomorrow it is going to be with. Tomorrow with fine.
Fine.
Senior counsel is here. Nothing, heaven is not going to fall down if it is not today or tomorrow. It is only payment of fine, Allah. When is the exam? Release this matter tomorrow. You have to, not able to hear you. Please take the mic and just closer to yourself. What is the order? Annexure C. What is Annexure A?
Second key, how to pass by the appellate authority. Yeah.
What is Annexure C? Page 20. Delay of how many days? 180. Is there a time limit prescribed for filing the appeal? 12 days. Prescribed under the Act. So now you have paid the amount.
But earlier amount I paid, this amount I paid.
What is the earlier admitted amount? 21. So only now recovery of amount. Possession handed over. ಎಷ್ಟು ಇವಾಗ ಡ್ಯೂ ಇದೆ? They have provided calculation. 6,44,000. Okay. Now what are you seeking? No, interim order what you are seeking? Interim order ಬೇಕಾ ನಿಮಗೆ? ಬೇಕಾಗಿಲ್ಲ. Issue notice ಮಾಡಿ. ದೇವರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿಲ್ವಾ? Emergent notice to the respondents. Release after service of notice.
Number 58.
Here insurance. Bhandari is for claimant. Where is he? Bhandari. In the death case or injury? Injury case. Huh? Baby of 2 years sustained injury. What's the disability? We'll have it next week. For representation on behalf of appellant. Counsel for respondent number 3 is present. Relist next week.
59.
You're for the insurance company. Corporation. Please lift the mic up so that I. Two claim petitions for instance. So in injury case, there is no appeal by the claimant. In death case, there is appeal and counter. But what are the facts? So you're on the question of quantum or liability? Huh? Was on which vehicle? The deceased was on which vehicle? Maruti Omni, na? Hmm. The charge sheet and FIR is filed on both. FIR and charge sheet. So FIR is filed against the driver of the van, Janardhan. Hmm. Ready. Divya.
Hotel 57. Serial 57.
What do you want to read? Two 337. Two is the sketch. Then the left to right is what? The vehicle Maruti van was going from which direction to west to east will be. Sketch idea matra. The north south east west idea. Tara dakshina. This is a sketch, Allah. This is a sketch. So in this, the van is coming from this side. The sketch. East, west to east. Sketch. Please show me a sketch. You select sketch it called. What is this? What is this? What is this? South to north. Male east. Male east. East. So north to south. Take that mic little strength in your hand. One is you are so slow, the feeble. I have to hear you. Mic ಇನ್ನು ಸ್ವಲ್ಪ front bend ಮಾಡ್ಕೊಳ್ಳಿ. Bend ಮಾಡು. ಇವಾಗ ಹೇಳಿ. So the FIR is also against the Maruti van only. KSRTC bus has been roped in by the tribunal. Tribunal has fixed the liability on. What happened to the tribunal case? The person died, nothing else. That's an argument. On the point of negligence. So according to you, the entire liability is to be on the insurer idara. The insurer of the virus made a party. Huh? Who appears? Managing director. India Insurance Company, Lakshmi Chambers. So in 5002 is the death case, Allah? So in the death case, they have not made insurance a party? Whether he is a driver or owner of the owner come drive. So in his case, the insurance company is not part. Huh? So who appears? Insurance company. Who appears for insurance company? R6. Rashikar Illi. All. All right, you come to the death case first. So death case only you are appearing for the claimant. What is the order passed by the tribunal? So in both the liabilities against you, in both cases, only the 50% eligible. % each. Driver of Maruti and driver of KSRT equally negligent contributed 50% each towards the accident. Para 30. So in the second case of injury, 25,000 is awarded. Great. Yes. Yes, sir. What he has said. Great. RW1 evidence. Devaraje Gowda. RW1. So what is the reason for the tribunal fixing liability of 50% on you? What is the reasoning? Who is the complainant? India, UDFIR. Prakasha. Question of the deceased or the claimants would not be entitled now from you. Us. The payments who are the deceased, whether they can claim compensation from his own insurance company. ನಿಮ್ಗೆ ಗೊತ್ತಿರ್ಬೇಕಲ್ಲ our insurance company. But he's not even made a party. No, in the death case, so he was the only one traveling. Who was traveling along with him? So he will be entitled. No. The owner of the car is Janardhan. He was the driver also. Insurance company is with the Oriental. So even in case this court holds that the entire liability on the deceased, in the injury case, he will be liable to pay the injured. But what happens in the death case, whether he can claim? Huh? So even 163A also he cannot file anything. No. Oh, 63A only. 63A only. We could have claimed from you. Because negligence is not required to be proved. Policy Allah. 63A is a structured formula as per the schedule. Anyway, that is not their case. Yes, Astin and Nimbu. Yes. Page number 13. You are reading page number 13 of the judgment in the complaint. He did. Right now you are defending the judgment and seeking a enhancement. No, your case is seeking enhancement, Allah. All right, now how do you sustain the fact that the driver of the Maruti van who was accompanied by that inmate Balaji, he suffered injuries? Why he did not lodge a complaint? Is it? Is it? This is given by Balaji. E3. Who's the complainant? Which is the first complaint? What is that? Delay the FIR first. So UDR FIR, what is the provision? Unnatural death estate. Yes. So you are trying to now say that the exhibit P3 is lodged by you. Sandrine. Who's the complainant?
ಇಲ್ಲ ಸ್ಟೇ ಮಾಡ್ಲಿಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲ ಅಲ್ಲ ಅಲ್ಲಿ
Yes, where is this attributing against the driver of the bus? ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ ಸೆಕೆಂಡ್ FIR ನೀವು ಮಾಡಿದಾರ ಅಂತ ಎಲ್ಲಿದೆ? Take this. So this is pursuant to the doctor declaring dead. So that's why 304A is included. ನೀವೇ ಹಾಕಿದ್ದೀರಿ ಅಂತ ಎಲ್ಲಿದ್ರಿ ಈಗ? New case you are bringing up in the appellate court. There is no complaint lodged by your client Balaji or anybody else on behalf of Maruti Omni or any third person who has watched or witnessed the accident. So how the tribunal comes to a conclusion that the driver of the bus is also negligent by 50%? Near Oh, you are gone to the court. You have to establish your case, not he. How? How?
It's created by
Who's PWT? Read it. Evidence.
Be given by a fresh sheet developer. Any number to be given by somebody else. We are getting clear data. But the my present. I was really because my we were unable to lodge any report. We are unable to walk. Sir, as I information condition
Yes. We have not sustained any fractures also, Balaji. For insurance, ನೀವು ಇನ್ಶೂರೆನ್ಸ್ ಅಲ್ಲ ನೀವು ಬಾಲಾಜಿ ಡಾಕ್ಟರ್ ಬಾಲಾಜಿ whether he has sustained fractures. 8th and 9th ribs.
There were about there was 20 cases. That's why I asked and I false. They had made that was what false is that
So you have not registered any complaint against the KSRs. All right. Secondly, you also argued that the Maruti van was towing another vehicle. Yes, where is this theory now suddenly picked up? No, you have stated in the complaint does that mean? Read it loudly. Kachikonda. Does it mean towing? No, that must be, he must be closely coming. Huh? Katti. Chikonda anta. Where is this new theory you have floated? Police are markondiradaga, then the sketch also is unbelievable now. All right, if that is the complaint, by whom? Then the sketch is also manipulated. Because you have now created new story. See, if your case is that the Maruti van was towing one more vehicle. No. That's your case. See that apart from this statement here, in the evidence of PW1 and 2, nothing is coming forth with regard to towing of a vehicle. Then that is your FIR. Chikondu, what is that? Page 13. So what is wrong in the tribunal judgment? You should have kept quiet. You have said now that the Maruti van was towing one more vehicle. Kattikondu. Kattikondu is tying on linear method. Katti is tying. Why you said Kattikondu in on vehicle bantu? No, it can't be Kachikondu. It has to be Kattikondu. Why they will cross it? This is your case. We have not even uttered a single word about the Maruti van towing another vehicle. Nim driver. Our driver illa helakke. Why they should say something which is going to hurt them? See, they have put forth the case of accident by stating that your bus is negligent. Now you have come up with the theory because the FIR is registered by you. In the FIR complaint registered by your driver, he says that this vehicle was bringing another vehicle by towing, Kattikondu. The tribunal also has given a clear reasoning on the Kattikondu. So the tribunal in its wisdom has also appreciated the evidence which you have stated of towing of vehicle. If that was the case, then the sketch which you are now very vociferously relying. If this vehicle was towed, obviously that vehicle which was towed would have also met with the accident. Where is that vehicle in the sketch? Then your case is now unbelievable. You have hit your own foot. See, one more aspect is you have also not said anything about the towing of vehicle to them in cross-examination. ನೀವು ಹೇಳಿಲ್ಲ. ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದೀರಾ? What is your evidence? PW3 ಯಾರು? RW1.
Driver and work with other vehicles. It was observed by the motorcycle duty on the right side of the road. Same motorcycle driving by the driver and dashed against my bus, crashing into him and clearing my walk on the road. Also continued to do its bonus. In the area of the Children was coming close to him. People had to come to the village. This is advantage and advantage.
No, the police did not prepare the sketch at the spot of action. So you are admitting police did not prepare the sketch at the spot of action. Huh? It was prepared in the police station. ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರಲ್ಲಿ no. It is police did not prepare the sketch at the spot of accident. Where is the Mazar? There's no Mazar. Huh? After FIR, intimation. Yes. The spot master. Where are the signatories to that, Mazar? Right, we are two na. Finally, they ಹೇಳ್ತಾ ಇರೋದು. R1 is the FIR. ಅದರಾದ್ಮೇಲೆ ಒಂದು ಸ್ಕೆಚ್ ಇದೆ. ಇಲ್ಲಿದೆ. Where are the signatories? Mazar. How to believe this? It is prepared by the police in the police station, even according to you. Police did not prepare the sketch at the spot of accident. What do you say? Police did not prepare the sketch at the spot of accident. It was prepared in police station. So, preparation of sketch at the police station. How to believe your sketch?
Police did not prepare the sketch at the spot of accident. Was prepared the police.
Mazar draw ಮಾಡಬೇಕಾದ್ರೆ ಯಾರು ಇರಬೇಕು? He is the one important person who has seen the accident. He should have been there in the Mazar. So your theory of coming on the left side of the road, everything goes for a toss. No, the car coming to the right side of the road and damage itself is based on the premise of your sketch. Huh? No, one bus was going ahead of Maruti only. That is a different bus. No, your premise of we looking at it on the spot sketch itself is now fallen flat on the ground. Now the sketch is to be unbelieved. So if we forget about the sketch, because you don't know and you admitted that sketch was not prepared at the spot. Who are the signatories? ಯಾವಾಗ ಮಾಡಿರೋದು ಅದು? Who are the signatories? That's all. What is your case? Now you have filed two appeals, one against the death case, one against the injury case. Nimdeno on what ground? You are asking enhancement on what ground? Engineer. Your income tax assessee. What is your income shown? 13. 700. Right. That is their income. This is your income. Only. What's their income? ಎಲ್ಲಿದೆ? Where is it? 13,000, where you assume? In the income tax returns where it is shown that you are earning 13,000. Why it's not shown? And how you say it is 13,000? So you will tell so many things. You don't know how to see in the income tax returns. And then you should meet some chartered accountant before you come to argue. Total income idea? Divide madak baralla. What is taken by the tribunal? ಜಾಸ್ತಿನೇ ತಗೊಂಡಿದ್ದೀನಿ. Which paragraph? Notional income of 4,000 as per exhibit P5, age is 36 is correct. Hmm? P9. As per P5. ₹4,000 ತಗೊಂಡಿದ್ದಾರೆ. You are saying how much? 8,000. You want me to take what you have said? Entry, Mr. ₹4,000 ಹೆಂಗ್ ತಗೊಂಡಿದ್ದಾರೆ? Your income tax returns he has paid? Huh? No, 1999, that's on date. And even after that, 2001 is his accident. 99 years given returns. He's doing some metal work. Adral ideyala avadu income 87,992. How the tribunal has come to 4,000? Proprietary firm alva adu. License. Why license is it's a different thing. You prosecute him for not having license. He has paid income tax returns. No, the income tax returns is paid for which year? Matte 99, 2002 or 2 years. Oh, it will continue when he has died. Proprietary firm on the brothers help. That returns is enough to calculate his income. Sir, it is need not continue when he dies. That is our case. If it is continued, then you have to show that it is continued by the wife. There is no deficiency or that lack of income. No, you have to produce or you have to cross-examine that despite the death, the income is coming. Whether income comes or not, when the firm is continued or not, he, the main proprietor, is dead and gone. Continued or not, he is gone. His ability to work and earn that money is gone. So that amount is less. I would take 7,000 rupees per month, even according to that. Which is that document exhibit? Income tax.
P7 and P8.
Yeah, was it? Double 5, 6, double 8. ಇವೇನೆಲ್ಲ ಓದ್ತಾರಲ್ಲ ನಾವು ನಾವೆಲ್ಲ ನಾವು ಓದ್ ಬರಲ್ಲ ನೀವು ಮತ್ತೆ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ ಅದು 155 688 12,974. What is this from the speech? Income tax ಇದಿರ್ಬೇಕಲ್ಲ statement of income. Really 1,55,000 for the year 2001. Exhibit P8. How many of them are the dependents? ಕರೆಕ್ಟ್ ರೀ, ಅದು ಡಿವೈಡ್ ಮಾಡ್ಬೇಕಲ್ರಿ. See in the total income. See the income. Next page ಅಲ್ಲಿ computation of income ಇರುತ್ತೆ. ಅದರಲ್ಲಿ income, total income ಅಂತ ಇರುತ್ತೆ. ಅದರಲ್ಲಿ 155,688. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ನೋಡ್ರಿ ಕಂಪ್ಯೂಟೇಷನ್ ಅದು ಇಲ್ವಾ? That is the income statement filed by the chartered accountant to the tax authorities. So in that, if he has declared his income as 155,688 and paid income tax of 22,000, then why we should deny him? A person who pays tax, you don't want to pay him. A person who doesn't pay tax, you want to pay him compensation. For dependents, how much is to be deducted? On fourth. So we have to take the 12,974. We rounded off to 13,000 is correct. What is she stated? $10,000 can be taken on calculation of both and divided by 2. Because the 2,000 ಅಲ್ಲಿ ಜಾಸ್ತಿ ಇದೆ, 99 ಅಲ್ಲಿ 7,000 ಇದೆ. So both plus ಮಾಡ್ಕೊಂಡು divide by 2, 10,000. So we'll round it off to 10,000. Age is 39, Allah. So what is the multiplier? 15. Huh? It will be 7,500 into 12 into 15. $13,50,000. So what about his age 39, and then you'll have to add that 40%. How much has to be added? It's rounded off to 10,000. Average ತಗೊಳ್ದ್ರೆ 12,974 plus 7,332 ಮಾಡಿ 10,000 ಮೇಲೆ ಬರುತ್ತೆ. 12,974 plus 7,332. Huh? $974 plus 7,332 divided by 2. 10,153. Profit already. That income is there. 87,000 something is there. $10,500. $18,90,000. ಎಷ್ಟಿದೆ ಇನ್ಕಮ್? ಕೊಡಿ ಅದು IT ರಿಟರ್ನ್ಸ್. How much you said will be the income? Per month, how much you said the income will be? No, how much you said? Deduct money. You also deduct. What are you standing there and doing? That's all. That's all. ಇಲ್ಲ. ಏನ್ ಮಾಡ್ಬೇಕು ನಿಮ್ ಕೇಸ್? Or by tribunal is correct.
Even though in absence of
Court has taken consideration and rejected your appeal. The deceased Janardhan, deceased Janardhan was an income tax payee as per exhibit P6, P7 and P8. The income tax returns for the year 99-2000 shown as 87,992. And he has paid income tax of rupees 6,598. For the next year of 2000, as per exhibit P8, the income is shown as 1,55,688. 1,55,690. And the income is tax is deducted at 20,707. Huh?
Tax at 21,000.
Pretty much. Rate 21,000. Chalan. You have to see the first sheet. See, income is different from other. Tax you'll be paying on other income of your surcharge, income tax paid, details and other things. That is self-assessment tax paid. We are not concerned with that. Income tax due. Income tax payable. But you won't take it in challenge it. 20,707. By deducting 1,55,000 from 690 comes to 1,34,983 for the year 2000 to 2001 assessment year. For the previous year, on deduction from 87,992 to minus 6,598, 81,394 is the amount. Therefore, dividing the same by into 12 to arrive at a per month income for the year 1999-2000 it is 6,782, and for the year 2000 to 2001 it is 11,248. Adding both and dividing the same by 2 to arrive at an average, it comes to 9,015. Same is rounded off to 9,000 to assess the income per month. The income is taken as 9,000 per month as against 4,000 adopted by the tribunal. Full stop. The claimant deceased being aged 39 years. 40% will have to be added towards future prospects. Adding 40% to 9,000 is 12,600. In view of the fact that the deceased has left behind 4 dependents, 1/4 will have to be deducted towards personal and living expenses, which is 3,150. So 12,600 minus 3,150 is 9,450. Stop. Deceased being aged 39 years, the appropriate multiplier would be 15 in accordance to the judgment of Delhi Transport Corporation versus Sarla Verma. Therefore, 9,450 into 12 into 15 is 1,70,000, 1,000. Para. ಮತ್ತೆ ಹೇಳಿದೆ 17 lakhs 17 lakhs 7 lakh 1 lakh ಹೇಳಿದ್ದೆ ನಾನು ಏನು ಹೇಳಿದ್ದೆ 17 lakhs 17 lakhs 1,000. All right. Next para, in view of the 4 dependents, 40,000 each they would be entitled to as consortium in accordance to the judgment of Pranay Sethi 2018. Magma and Satinder Kaur thereafter followed. 15,000 towards loss of funeral expenses and estate. Together 30,000 on conventional to 30,000. Therefore, 1,90,000 under conventional head. 10% will have to be awarded in view of Pranay Sethi's case. 19,000 is awarded. Therefore, in all, the claimants would be entitled to a total compensation of yes, para, in view of the fact that the tribunal has passed on 50% liability as against the deceased himself in view of the fact of the FIR being filed and 50% as against the corporation, the same is retained. Adana 50% money, 50% of that. $9 lakh. The claimants would be entitled to 50% of the total compensation amount, which is 9 lakhs so and so. Along with 6% interest from the date of petition till realization. In view of the fact that the respondent corporation is fastened with 50% liability, the respondent corporation would have to pay 9 lakhs so and so to the claimants from the date of petition till realization of 6% per annum, which shall be paid within a period of 6 weeks from the date of receipt of copy of the order. In view of the judgment passed in this case, it's a common judgment. First and two common aಗುತ್ತೆ. Because your now appeal is going to be rejected because of your claim, which is now their appeal is going to be partly allowed. Death case. In the other case, that is going to be dismissed because nothing is changing in there. Adal 50-50 madidare. They are not in appeal. So that will get dismissed, affirming the order. Injury case. Our appeal will read. ಕಡಿಮೆ ಹೆಂಗಾಗಬೇಕು? Pain and suffering ಎಲ್ಲ ಕೊಟ್ರೇನೋ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಬರುತ್ತೆ. No, if this court is going to consider, it will be more than 50,000. He will get more than 25,000. The second 59.2 appeal. 59. Yes, 59. Amount in deposit. You deposited any amount here? Statutory deposit plus other deposit. The entire amount in deposit made by the insurance company before this court to be transmitted to the jurisdictional tribunal forthwith. The entire compensation amount of apportionment madidara. ಏನ್ ನೋಡ್ಕೊಂಡ್ ಬರಲ್ಲ ಫೈಲ್ ಓದಲ್ಲ. First lady's wife. All have attained a majority ಇರ್ಬೇಕು. So what happens is 10% each ಕೊಟ್ಟಿದಾರಲ್ಲ. Let it remain. That the apportionment made by the tribunal stands intact with regard to 70% of the compensation to the first claimant, wife of the widow of deceased Janardhan, and the 3 children would be entitled to 10% each. Two and 3 children, 4 is the mother. All the 3 are children. ಎಷ್ಟು ಬರುತ್ತೆ ಅವ್ರಿಗೆ 10% of 9 lakhs? 1 lakh ಬರುತ್ತೆ. 90,000. The amount 70% ಎಷ್ಟಾಗುತ್ತೆ? 9 lakhs. Out of the compensation amount awarded to the first claimant, is the widow of deceased Janardhan, 50% of the amount be permitted to be withdrawn, remaining 50% to be kept in fixed deposit in any nationalized bank for a period of 3 years. The remaining amount awarded to the claimants 2, 3, and 4 shall be dispersed in favor of the claimants upon proper verification. Huh? In the your question trying to say that he's negligent. This is the contention of no, that is affirmed. Then there is a contention of learned counsel for the corporation that the entire negligence is to be attributed on the deceased who was driving the Maruti van, and liability has to be fastened entirely on the driver of the Maruti van, the deceased Janardhan. So also for the reason that the charge sheet and FIR has been filed as against him, the abated charge sheet. The tribunal has carefully considered these aspects on the ground that the charge sheet is filed against the owner of the Maruti van, who is none other than the driver cum owner who is deceased. But however, on looking into the complaint charge sheet, FIR and the charge sheet on the spot sketch, which is claimed to have been lodged by the driver of the KSRTC bus, it does not instill confidence in the court that the entire negligence is on the driver of the Maruti van, because it is a case of the corporation that the KSRTC bus was driving cautiously and slowly on the left side of the road, and he had immediately gone and lodged a complaint before the police against the driver of the Maruti van, But initially, he has given a complaint stating that the Maruti van was towing another vehicle. But the same is not forthcoming in this spot sketch, which is relied by the counsel for the insurance company at Exhibit P3. And so also it is seen in the cross-examination of RW1, who's none other than the driver of the bus. He has admitted that the sketch was not prepared at the spot of the occurrence of accident, and that it was prepared in the police station. Yes, said something at the police station. Therefore, considering the admission of the driver of the KSRTC bus, was categorically admitted that the sketch was not prepared on the spot by the police. The entire case of the corporation is doubtful, including the complaint registered by the driver of the bus. And so also Exhibit P3, the spot, the R3 sketch, the spot sketch, and the Exhibit R2, the spot sketch is also doubtful. Hence, in the wisdom of the tribunal has come to the conclusion that there could be part negligence on behalf of by the KSRTC bus driver. Accordingly, fastened 50% liability against the corporation, which I do not find is illegal, arbitrary, or perverse. Accordingly, the contention put forth by the Learned Counsel for the corporation is rejected. When you argue MVC case, you should come with all statistics and mathematical calculation, not come here and stand and you wasted so much time of the court. ಮತ್ತೆ ಇಲ್ಸಮ್ ಬಂದು ನಿಂತ್ಕೊಂಡು ನೀವು ಆವಾಗ ಪೇಜ್ ಟರ್ನ್ ಮಾಡ್ಕೊಂಡು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಹೆಂಗ್ ಓದಬೇಕು ಗೊತ್ತಿಲ್ಲ. You have to read how the income tax papers are prepared, how Saral paper is filed, what are the deductions. If you don't know, you have to sit with the chartered accountant. Shastri, no representation on either side. We list next week after next. Next week, 2014. All matters next week beyond 15. ಯಾವುದು ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ court officer, wherever interim order is there, it will be extended. ಟೈಮಲ್ಲಿ 5 ಮ್ಯಾಟರ್ಸ್ ಮುಗಿಸ್ತೀವಿ.
ಕ್ಲೆಮೆಂಟ್ ಅಪೀಲ್ ಆದ್ರೆ ಬೇಗ ಹೋಗುತ್ತಲ್ಲ, ಇನ್ಶೂರೆನ್ಸ್ ಅಪೀಲ್ ಆದ್ರೆ ಲೇಟ್ ಆಗುತ್ತೆ. ಕ್ಲೆಮೆಂಟ್ ಅಪೀಲ್ ಇದು ಇನ್ಶೂರೆನ್ಸ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಲೇಟ್ ಟ್ರ್ಯಾಕ್ ಮಾಡಿ, ಕ್ಲೆಮೆಂಟ್ ಅಪೀಲ್ ಸ್ಪೀಡ್ ಆಗುತ್ತೆ. ಅಲ್ಲಿ ನೋಡಿದ್ವಲ್ಲ ಧಾರವಾಡದಲ್ಲೆಲ್ಲ ಸ್ಪೀಡ್.
ನನ್ನ ಮ್ಯಾಟರ್ಸ್ ಅಷ್ಟು
ಬರಲ್ವಾ
Hello. 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 Hello.
ಹೇಳಿ ಸರ್ ಹೇಳಿ ಸರ್ ಹೇಳಿ ಕೇಳಿಸ್ತಾ ಇದೆ ಹೇಳಿ
Number 60. Serial number 63.
ಹಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್
Serial number.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
Hello.